Mention my process.
All rise. The Honorable Court of Appeals for the 7th District of Texas is now in session.
Please be seated. Welcome you to the April 2nd settings of the 7th Court of Appeals. We have one case to hear this morning, and the attorneys representing the parties today. I think it's kind of a redo. We just saw them less than a month ago in Houston. Appreciate you going down to Houston again. Appreciate seeing you guys again here today. We're looking at having settings in San Antonio. Would you like to come argue down there again? We'll go on and call the docket, dispense with the formal discussions of our protocols or procedures since you've argued here before. So we'll just go on and call the docket. First case we have today is 07-24-00214-CV. Joel Hart Advanced Power LLC and Hydrostar Energy LLC versus Curt Besselman. Mr. Smithy, assuming you're ready.
We're here on behalf of the appellate. Eric Wolfram is here with me. I'll be doing the argument, and we are ready. I would anticipate taking the full allotment, close to the full allotment of time.
Very good. And you know you have 5-minute rebuttal. And it's Mr. Wolfram, it's good to see you here. You were flying solo in Houston, so you got a co-pilot now. So, and for the appellees, Mr. Mullen.
Yes, Your Honor. David Mullen, Richard Biggs here on behalf of the appellee, Curt Besselman.
Very good. And Mr. Mullen, you're going to be doing everything. You're going to tag team. I know you didn't do that in Houston, but what's your preference today?
I'm going to do it all the day unless I need assistance.
Okay.
Which I hope I don't.
Thank you very much. With that said, Mr. Smithy.
May it please the court and counsel. Back on February 27th of 2019, this dispute was completely settled. It was the parties had entered into a mediated settlement agreement after a day of mediation. Both parties seemed to be very pleased with the deal they had struck. And so the case was over before it was even filed. There was no lawsuit at the time, just a dispute between the parties.
If I may, just to confirm what I'm thinking, the MSA settlement agreement refers to possibility of following it up with a more comprehensive document. Was there another document or was it just this MSA?
I'm not aware of anything in the record that had a more comprehensive settlement agreement, just this MSA that's entered into here.
Thank you.
And so what happened? Why are we here, 6 years later? Well, to put it in using the plaintiff's own words, from the appellee's own words in this case, he says from his second amended petition, he says, at the time the MSA was entered into, the parties expected that it would take 2 years to build the U.S. Virgin Islands wind farm, which of course the farm, a lot of the consideration, the biggest part of the consideration that the plaintiff in this case was going to get was from the generation of electricity in the Virgin Islands. And so it was dependent on that project being built and completed and producing within the 4-year window that was in the settlement agreement. But you know, he goes on and says that by all accounts, the project was nearing completion by early 2019. The Power Authority had completed the studies, and all that was necessary was signatures to the contracts. But the project was suspended for 3 times for reasons outside the control of any of the parties. And he mentions first Hurricane Irma, which had struck in the Virgin Islands back, I think it was 2017 or 2018. It was a historic hurricane, and there were 2 back-to-back hurricanes that hit the islands, did a lot of destruction, and it took much longer to recover from those hurricanes than anybody thought it would. Second was COVID, because right in the middle of this, after the settlement agreement had been entered into, COVID hit in 2020, and those 2, and he's right, you know, those 2 circumstances basically delayed and then ultimately killed the project. And finally, he says, and this is true, there was an ambitious senator in the Virgin Islands legislature. The legislature had to approve the contract, and when to build the wind energy down in the Virgin Islands, and the senator was successful in killing the project, in killing approval. He was running for governor at the time. And so plaintiff says the unexpected political interference prevented the consummation of the ground lease and deprived Besselman of his commission. And it says at the time that Besselman and defendants entered into the settlement, they both believed it would take 24 months to construct the wind farm, and it would be approved in the near future. They both believed this. But because of the mutual mistakes, and so he asked for reformation of the agreement. Well,
that's in the second amended
Yes.
petition, but he went to trial on the 4th.
yes, he amended. So this suit was first filed as a suit to recover under the settlement agreement. And because they thought that there was going to be money under the settlement agreement, you know, there wasn't, because there was never a wind project built, no electricity was ever sold. So when they realized that the project wasn't going to be built, then they sued for reformation. Well, you can't get reformation just because the circumstances don't work out the way you may have contemplated when you entered into the contract. And so they dropped their reformation claim, and in the pleading they went to trial on, it was for rescission of the MSA. And the rescission was primarily based upon what they alleged was a statement by a lawyer, Louis Coppage, who said that in a letter to Mr. Besselman's lawyer, said the project has been basically on hold for over a year and may never be built, which was the absolute truth. Once the Power Authority down there had approved going forward with the project, nothing happened for really 3 years. And ultimately the project died. So nothing ever happened on this. So the statement was true. And so they're trying to get out of this agreement by saying, you defrauded us. You made a false representation. Well, first of all, it makes no logical sense at all to say you were trying to get me to sign an agreement that was dependent on this project going through, or I wouldn't get anything. But you told me, you induced me to sign this by saying that the project might very well never go through. I mean, that seems to be a very honest and turned out a very prophetic statement, because the project didn't go through.
But and correct me if I'm wrong, but during that same time, were there discussions with entities in the Virgin Islands to sell electricity? Were those discussions ongoing, and weren't there some contracts that were actually executed to sell energy?
Yeah, the timeline is interesting, because the deal is tentatively approved in October 17th, where the Power Authority said chooses Advanced Power, one of the parties here, to build this wind farm in the Virgin Islands. That's in October 17th. So they have some meetings in early 2018 in Miami to try to negotiate. Well, nothing really comes out of the meetings. And so the Power Authority thus then becomes pretty much non-responsive. And so in July, we're notified Advanced Power is notified that the Power Authority has suspended all negotiations and that they're going to work on building their own wind farm. So that was in July of 2018, and this letter from Coppage went out in December of 2018. And that's when the letter was sent. So this was going on. So
That's the letter that said things are dormant.
yes, things have been dormant for a year, and it may never be rebuilt, or it may never be built. So they do so when they get to the mediation, they were hopeful that a project might be built, but there was no contract in place yet. Nothing really had happened at that point. So they do this mediation, and as Mr. Besselman said in his pleading, everybody was still optimistic that this was going to happen, but they just didn't know for sure. I mean, it was still contingent. So, but they signed this agreement in February of 2019. Well, as it turns out, the negotiations don't resume until May of 2020. This is totally out of our control. We're ready to do it today, but it's the Power Authority that just keeps putting us off. So in May of 2020, over about 15 months after the settlement agreement's reached, they start talking again. And then it takes almost a year. It takes 11 months into April 2021 to sign a contract. So they signed this conditional contract in 2021. That's over 2 years after the settlement agreement had been entered into.
When you say conditional contract, are you referring to the power purchase agreement?
Yes, the power purchase agreement. And it was contingent on a number of things. One of which is the legislature. First, they had to enter into a lease agreement to lease this ground from the government, and the legislature had to approve the lease agreement, and that's what caught the deal. But you've got other contingencies as well. You got to get the financing. You've got to get the plans approved. I mean, it's just a real process to get that done.
So the PPAs they were referring to occurred after the MSA was signed, a year after. So
Yeah, it was after the settlement agreement.
is there any evidence in the record to indicate that those discussions that resulted in the PPA were ongoing at the time that Mr. Coppage wrote his letter saying everything's dormant?
No, they weren't ongoing because they had been suspended back in July, totally suspended. So there were no negotiations going on at that point. Now, Mr. Hart never lost, who was driving this, would never lost hope that it was going to happen. He just very optimistic, and we're going to get it done. We're going to get it done. But once again, it was out of his control. He had very little control because he was dependent on the Power Authority to go forward with this.
The fraud needed in order to get rescission, false statement. The statement had to be false at the time it's made.
Yes, and since it was made by a lawyer who was not a principal in the company, we've cited the cases, but you have to show that he had the mental state to commit fraud. In other words, he knew the statement was false. He intended for the actor to rely on it. And so there's no evidence that Mr. Coppage, no evidence really that the statement's false, but even if you assume it was false, there's no evidence that Mr. Coppage knew it was false. He wasn't a witness in the case, and there's no evidence of what his state of mind was at the time. You've also got the intent to rely. And like I said, the reliance here is completely illogical that you would sign an agreement that says you don't get anything unless the power plant's built. And you say to sign that you were induced because somebody said the power plant may never be built. And so not only is it illogical to say that someone relied on that, but how would Mr. Coppage know that that statement was going to cause a reliance? It would tend to cause a non-reliance in that situation. Now, the other aspect you have in this case that's really important is at the mediation, part of the mediated settlement agreement includes what goes back to the Schlumberger clause where you say it's a disclaimer of reliance. And you say neither party is relying on any representation in entering into this agreement. And that's in here. We have both a merger clause and a disclaimer of reliance. We have both in very clear language. First, this agreement contains all agreements and representations relating to this agreement. And then the second part of it neither party is relying on any representations in entering into this agreement. Now, the Supreme Court has said over and over and over that those clauses are enforceable. They mean exactly what they say. And so if you're a party, and particularly as here, where you're represented by a lawyer, both sides at the mediation were represented by lawyers. So when you sign that, you're charged with what you sign, and it says, I'm not relying on any representations. And if you are relying on a representation, you see that, you have a duty to say, hey, wait a minute, you told me this, and I wouldn't be entering into this agreement if you hadn't told me this. And then, if you want to, you can put it into the agreement. We're relying on your representation that the project would never be built. But that's just not the case here, because you have an express agreement that the parties were disclaiming reliance. And, one of the latest cases is the Transcom case that we cited, where the Supreme Court said, the parties are entitled to bargain to end this dispute once and for all. Because, who's going to mediate a case if you mediate the case and settle it, and 2 years later, you're going to have another lawsuit? Parties ought to be able to end a dispute once and for all and not have to come back into court. And
question with regard to your reliance. The provision in the agreement says there are no agreements or representations concerning this agreement which are not included herein, and the parties are not relying on any representations or non-disclosures. Reference to the representations and non-disclosures, does that refer back to this agreement, or does representations and non-disclosures, in your view, encompass anything?
Well, I think the way, if you read it literally and on its face, it's anything, because there's one sentence, this is one sentence that the court's referring to. And the sentence, interestingly, contains both a merger clause and a disclaimer of reliance. And, the Italian cowboy case out of the Supreme Court, which is cited in their brief, basically talks about the difference between the two clauses. And in the Italian cowboy, the party that was seeking to, the defendant in that case, said, okay, they signed a merger clause, so you can't have any reliance. And the Supreme Court said, no, these are different clauses, and just a merger clause isn't expressly a disclaimer of reliance. Okay, so they say, if you want to disclaim reliance, if the parties want to do that, they have to do that in clear language. So you have one sentence here that has both the merger clause, which says no agreements or representations concerning this agreement, which are not included herein. And then part two is the disclaimer of reliance. The parties are not relying on any representations. So it's not limited just to representations concerning the agreement, any representations or non-disclosures. So the parties expressly agreed that they were not relying on these. And the Supreme Court said, these are enforceable and they should be enforced, except in very rare circumstances. And none of those circumstances have been alleged, or is there any evidence to support any of the other circumstances or exceptions where you can get out of one of those agreements. One other way to rescind a contract is through a material breach of contract. And that brings me to the other part of this, and there was no breach of the contract. We did exactly what we said we were going to do. We paid the initial sum of $5,800. And the contract provided we pay a percentage of any revenue from sales generated on the U.S. Virgin Islands. Well, no project was built, no electricity was sold, and there were no sales. And it was in that 4-year window from 2019 to 2022, the end of 2022. It was a 4-year window, and nothing occurred in that time. So there was no trigger that would have triggered any obligation for us to pay anything. Now the trial court found that money we invested in the project she called that sales. And but they weren't sales. But the other thing, there was no evidence that it occurred in that 4-year window. We don't know when it occurred. In fact, it occurred before the window. Money that these companies had put into the project trying to get it built.
Are you talking about the expenses?
The
that
expenses.
court Attributed,
Yes,
or it's kind of like, I guess, imputed
yes,
income?
yes. Yeah, I guess suppose imputed income, but there's no evidence when it was when it all happened. And it had to happen in that 4-year period. And so the plaintiff had the burden to prove that it happened in that 4-year period, even if you assume it was income. And then there
This
was
is that 500,000 plus
yes,
expense.
yeah. There was no evidence when that was incurred. In fact, it was incurred earlier.
How is
Yeah.
that a sale, Bud, in your view?
Pardon?
How is that a sale?
It's not a sale. It doesn't fit the definition at all. It was
What
an
are they
investment.
referring to when they're referring to sales in paragraph D of the MSA?
Yeah, in our view, it's not a sale. I mean, it's a sale is when you're taking money in, that we were putting money out to try to develop this project.
Because my question, I guess, would be more a sale of what? It says reflecting all sales relating to entities in Exhibit A or projects in U.S. Virgin Islands. Since the relationship is contemplating the sale of electricity, are they talking about just the sale of electricity, or are they talking about the sales of anything? If somebody sold them a roll of computer paper,
Yeah.
they'd be entitled to a percentage on that.
Well, I mean, the only thing
Or
that
if
we
they
were
sold
trying,
the roll of
only
computer-
one thing we were trying to sell. We were trying to build a power plant.
Right.
The only thing we were going to sell was power.
Correct.
That was the only thing that we could possibly sell in the U.S. for a sale we could make in the U.S. Virgin Islands.
So would your suggestion be, and opposing counsel, please address this too, but would your suggestion be that you've got to read sales in relation to the relationship to the purpose of the contracts, the relation, that
Yeah.
you're selling power as
Selling
opposed
power,
to
yeah.
anything else?
I mean, that's what the parties were contemplating. They thought this project was going to get built and power would get sold. Now, let me address, I've got about a minute left. Let me address the quantum merit claim. So one of the essential elements of quantum merit is proving you don't have a contract. Because if you have a contract, you can't recover under quantum merit. So we don't think quantum merit has any application because we believe there was a contract and we didn't breach it. We don't owe anything under the contract. But if a quantum merit, the problem they've got, the judge awarded several $100,000 without really any evidence of the reasonable value of the work that was allegedly performed here. We don't deny that Mr. Besselman did a few things. In fact, he listed about 5 or 6 tasks he did, surfing the internet, making some calls. But for that to be awarded $300,000 for what it would amount, evidence of only a few hours of work in this situation, there's no evidence that would be a reasonable compensation at all.
Well, why would evidence of their past transactions and compensation pursuant to those transactions not be evidence of reasonable value?
I'm sorry.
In the past, didn't they
Well-
enter these deals and he got a percentage?
Well,
Why wouldn't that be reasonable?
there was never a case like this in the past, never. In the past, he had been out selling wind turbines that were installed. We weren't selling anything here except electricity. We were building a wind turbine. So the two transactions are totally different. And there's no evidence that there's no evidence in the record that what would be a reasonable compensation in one would be reasonable in the other. And so it's apples to oranges in our view. Thank you all.
Thank you, counsel.
Hopefully I'll get a chance to come back.
Yes, sir. You
Okay,
can.
thank you.
May it please the court. A lot of what Mr. Smithy has argued this morning is dependent upon the testimony of Mr. Hart and his documents that he prepared. And I will tell the court that the court below was completely justified and within its discretion to disregard any or all of Mr. Hart's testimony because he was repeatedly found to have been misrepresenting numerous facts in connection with the case. Let's start out with the whole financing thing. He represented to the USVI government that the companies had formally received and have in place comprehensive funding commitments from financial underwriting sources for the project for both the interim construction period and for long-term permanent financing for the life of the proposed wind project. He then gave an oral statement that was recorded, and we had it and we played it at the trial, saying exactly the same thing to the US government, excuse me, the US VI government, which is in essence the US government during this time period. And he made the same statements about the commitments. Then he testified in a deposition a few days after that there were no actual commitments. And his assistant, Mr. Sadler, also testified in his deposition, which was read into the record at the trial, that there were no financing commitments. And then we start off with that level of just, basically willing to say anything. At one point in the trial, he says, well, I was just trying to signal to them that it wouldn't rely on public financing. Well, you don't have to state falsehoods to do that. Just say it. And then he says, okay, so his agent, Mr. Coppage, sends me a letter, and it says the USVI project. And I noticed that Mr. Smithy changed the words. Okay, here's the words. The USVI project has been dormant for over a year and may never restart. And Mr. Hart testified under oath at his deposition that the project was never dormant. And the Coppage letter was not an opinion on the law. It was not an application of the law to the facts. It was a statement of specific historical fact. And they want to skim over the fact that the letter says for over a year. And they want to skim over the fact that by saying it's never restart, it will never restart, he's telling us that it was stopped.
Anything in the record indicate that Mr. Hart directed Mr. Coppage to make that statement or approve that statement before it was made or even after it was made?
We asked that, and of course they objected attorney-client privilege. We asked Mr. Hart on the stand. They said attorney-client privilege sustained, which clearly now where we are with them making this argument is a sword shield situation, which the court recognized that later in the trial and actually mentioned it. But the fact is they ratified it in this case. They ratified what he said in the case because they filed supplemental disclosures, which are exhibits number 7 in the record, that said that the project had been dormant for years. And they said there was no financing in their disclosures, which is exhibit number 7 at the trial. And it said there was no financing. So they've admitted that they misrepresented the financing issue, and this statement, was it dormant? You look at the documents that they can't escape from. Their own timeline shows that there were activities going on at this time where they were trying to move this forward. There was a time period there where they were seeking a cost study. It says right in the timeline they were seeking a cost study from somebody called B&V because they were trying to come up with the correct pricing of the project, and that they were waiting for the cost study. But that's not the project stopped. I mean, you're pursuing it by getting this cost study. And then you have Mr. Hart's own testimony that it's not true. And so in this case, you have something that's completely false that was given to us in December of 2018. And, they're trying to say, Mr. Coppage was actually listed on their will call testify in their disclosures. And of course, they didn't call. And he was, as their attorney, fully authorized to make those statements. And he either knew the statements were false or was reckless because as an attorney, he had a duty to verify factual statements he's making in a letter, at least by asking the client. And certainly in a case like this, looking at some documents to verify what's going on. And so you have that, and then you go forward in this case, and this is not the only examples of misrepresentation. I mean, he misrepresented on the stand what Mr. Besselman's job was, what he was doing for the company, and basically calling him a glorified gopher. But the testimony was that he was made $1 million on these school grant projects that Mr. Besselman worked on, and he bought an airplane with it for the company. And then he said that Mr. Besselman didn't do anything on this project, nothing at all. You know, he said that he testified to that under oath, and that was completely disproved by the testimony at trial. And what Mr. Besselman did is detailed in Judge Johnson's findings, and we have cited in our brief the references in the record. He said he didn't do anything. And then we go to the issue of the reports. And I want to make it clear to the court on the settlement agreement, because it is easy to. Yeah, go ahead.
Maybe before you segue to the reports, and I'm assuming you're going to be talking about breach of contract as a form of rescission.
Yes.
Before we leave the fraud, and let's assume arguendo that there is evidence of fraud. It was a misrepresentation when it was made and it was approved by Mr. Hart, even though Mr. Compton. You have what they call the merger and disclaimer clause. Talk to me about that. Why wouldn't that insulate?
Well, I want to talk about it at two levels, and one of the ties into the reports. But it's, first of all, if the contract is breached materially, we're entitled to rescission of the contract, and we're discharged from our obligations under the contract. So we can't both completely abandon the contract by, and the wording of the contract is important. It doesn't say on the money, on the payments of the 0.5% that it has to be a sale. It says gross revenue and funding from any source. So
About the reporting?
on the paying.
Okay.
And so exhibit number 2 is the HydroStar, just so that it's absolutely clear that part was breached. There's a HydroStar P&L exhibit number 2 in the trial that shows it's a P&L for 2022 and it says that they received $60,000 of income from the SODAR, which was bought for this very purpose of doing this project.
How much income?
60,000. And keep in mind what they did is that gross revenue and funding, the use of that term was to be very broad, because the cost
What does it
of
mean? What does it mean? It says gross revenue from any funds received.
right.
One reading it could say, well, that means you receive funds and then you generate revenue off of those funds. And then you get a percentage of the revenue generated off of those funds. So if we were to read it that way, what funds were received that they used to generate revenue?
Well, I think it's gross revenue. I mean, I get your point that it's net, but it's not a net revenue. It says gross revenue. So this is any kind of funding you get relating to this project is gross
But
revenue.
it says gross revenue from any funds received, which
Right.
connotes you receive funds and then you generate revenue off those funds. Am I misrepresenting that? Is that a way?
I don't think that's the way, I don't think that's the correct way to read it. I think the way to read it is that the gross revenue is any funds you receive in relating to this project. That is whether it's, I mean, they called it income on the SODAR, but there's also the money that they're getting when and this goes to the violation of the structuring provision of the contract, where they've got Mr. Sadler paying the expenses of the project, advancing the project directly.
Okay.
So
you'd want us to read it just as gross revenue, basically.
right.
A percentage of gross revenue and without relationship to any funds received,
Yeah,
just gross revenue.
I've always looked at the funding expanding the scope of it, not that we're expanding the scope of it, not reducing the scope.
How do we know that the SODAR income on Exhibit 2 is related to this USVI project?
Because the testimony was that this was, the only testimony about the use of the SODAR was on this project. That was the purpose of getting it, and it was to define the wind's ability to generate power at this site, the Bavoni Point.
Who testified to that?
It's in, I believe it's in Besselman's testimony, is the purpose of the SODAR. And I think he goes into quite a bit of detail about it. So we go on, so the breach is not paying him his share, but also not making the reports. And as we pointed out, a sale agreement for sales, Black's Law Dictionary, is a sale. And so we were entitled to receive the agreement, the April 21 agreement, power purchase agreement. We did not receive it. We did not receive reports, the reports that were required under the agreement. And then finally, he sent us one report that his lawyer, he testified his lawyer told him he had to do it. And then after that, he stopped doing it again. He just didn't do it even after his lawyer said to do it. And so there are breaches of that provision. There are breaches of the structuring provision. There are breaches of the payment provision. And those are material breaches that entitle us to rescission. And so we can't have it both ways. Now, let me address the Italian Cowboy issue. In addition, the language of this in this agreement, doesn't have the language of the other cases where it talks about disclaiming reliance on representations from certain parties, from the defendants, agents, and representatives. It just says disclaims reliance on representations. And that clause is right after the clause that says that there are no representations regarding this MSA. And so the only way to read that is to read it that second clause, the after the end, refers back to representations concerning the MSA. And clearly, Mr. Coppedge's letter is not about the MSA. And so it doesn't, this clause is much more like a merger clause, as in Italian Cowboy, than it is like the clause in, say, the IBM case or the other cases. And I would say this, if there's any ambiguity in this clause, if that's where we're heading here, because it doesn't say who those representations are by, it just ends it right there. It doesn't have by the agents of the defendants. If there's any ambiguity, then the judge is the fact finder on the resolution of the ambiguity. And so the interpretation of it, that it refers back to the MSA, is a reasonable interpretation and is binding as a fact finding. And so that's where we are on the whole Italian Cowboy, IBM, Schlumberger, all those cases. We think our position is that we don't have language that constitutes more than really a merger clause or a clause that prevents reliance on representations concerning the meaning or contents, legal effect of the MSA itself.
Does anything in the record indicate that in the discussions leading up to the MSA, Mr. Coppedge's representation about dormancy was discussed?
There was nothing about the actual events in the mediation as far as what people discussed. I mean, of course, Your Honor, there's a statute that would prevent us from doing that, but it wasn't even attempted to say what anybody said in the mediation.
I want to go back to the material breach.
Sure.
So is the SODAR an example of the material breach as far as something that should have been reported as a cell? And did that occur in the window?
It should have been recorded as a sale because it's in the 22, and it also is a fund, a gross revenue. So there should have been a payment.
Any
So-
other examples other than that SODAR as a
Well-
material breach?
Well, what we're saying is, look, he goes out and he gets Sadler, and then he uses his multiple companies so that one of the companies is paying the expenses of the other company. And by doing that, he's funding the program. It cost $500,000 to advance this project.
Right, but the reporting requirement was only if it was a sale happened. How does the expense of somebody else paying something for the company count as a sale?
No, fair enough. The point about the sale is the power purchase agreement and the SODAR. Yeah. So those are the two things. No, I'm sorry, I didn't answer your question.
So if the contract is rescinded, then we go back to the status of the parties
Right,
in 2019.
right.
Is there evidence of who plaintiff was providing services to? Which of these defendants?
He was providing the services. I would just say the evidence of the trial was that he was providing services that were benefiting all three. Mr. Hart personally, Advanced Power, Hydrostar. He did have the title of VP of Marketing of Hydrostar, but he was presented on documents that were submitted to the USVI people as being, part of the team. So he shows up as Advanced Power, he shows up as Hydrostar, he shows up as doing things for Mr. Hart personally. There's all of that here. And so
Of course,
his
your
work,
argument is that they're all one and the same anyway, alter ego.
right, because well, just the thing I talked about with the money flow, there's no attempt to keep them separate.
Well, don't you have to plead alter ego?
Well, it certainly was tried by consent. There was no objection to it. I mean, if it's not in the pleadings, I'm sorry if I haven't thought about that issue before this moment. But I think I think if we didn't plead it, it was certainly tried by consent here because there was, there was lots of testimony about it.
Looking at opposing counsel's reaction, he may have something to say about that.
Yeah, and on-
then, but let's go, assuming it's rescinded.
Mhm.
Quantum merit is the only basis for recovery that was allowed.
Quantum Merowit and of course, we had fraud claim, but I think it's both damages for fraud and quantum Merowit, but the quantum Merowit is based on what he would have gotten had there been no settlement.
It's based on what he would have gotten, but isn't the test the reasonable value of the services provided?
Yes, and that's,
Okay, and where does, you're talking about the commission now, is the reasonable value, and where's the evidence that that is a reasonable value?
two things. He said, Mr. Hart said to him that, when he asked him what he was going to receive on the project, we said, we'll handle it. It'll be something fair, like on the school grants. So we used exactly the percentage that he received on the school grants, which was 0.83.
That sounds more like a contractual agreement, though.
Well, but it's also evidence of what's reasonable under the circumstances. I mean, you're not going to find like there's a market for people doing this kind of thing. I mean, he's showing what could be more evidence of what's reasonable than what they've done in the past on similar on other work for this client, and the client had said that this is what was fair. That that was a fair approach. So that's it. Any more questions that I need?
Thank you, counsel.
Thank you.
Move on, maybe?
Well, I moved to extend my time to about 30 minutes.
Deny.
So anyway,
How much time do they give you in the floor of the house? Well, yeah.
well, extensions are liberally granted. Just a couple of points. One, this alleged statement was made 3 months before the mediation even occurred. There wasn't even a mediation planned at the time. You would think that at the mediation 3 months later, if this was such a big factor, that there would have been some discussion like, well, you told us 3 months ago this thing wasn't moving. Has anything changed in the last 3 months? But no evidence of anything like that. Justice Scarborough, to your question about the SODAR, no, there's no evidence that it did occur in the time window. We agree. And it was revenue. We agree. But there's no evidence that it related to a USVI project because it didn't. They had already done their SODAR measures wind flow. They had already done all that in preparation to get the contract in the Virgin Islands. They were moving on to other projects at that time. So you'll find nothing in the record that indicates it fit into the MSA because it was not related to a USVI project because it wasn't. So there's no evidence of that. And once again, the 500,000 of development cost, even if you could consider that to be revenue, but it was an expenditure, not revenue. But even if you could consider revenue, it was not within the time window. There's no evidence that it occurred within the time window. One other thing that Justice Parker, you mentioned was the who's it attributable to? Who was he working for? Well, the court awarded joint and several liability, but in the findings of fact, the court expressly found that these entities, including Mr. Hart and the two entities, were separate and distinct entities. The court expressly found no alter ego in this situation. So even if you assume it was tried by consent, you've got a finding that is just as binding on them as it is on us, that these are separate entities. And so you have no alter ego in this situation, and that finding hasn't been challenged. The other thing that it's interesting is they're seeking a commission. So a commission generally is triggered by an event. So like a contingent fee contract that a lawyer gets. We sign a contingent fee contract, and what it's contingent on is winning the case and recovering money. And so you get third or whatever of the recovery. So what do you have here is a situation like a lawyer signs a contingent fee contract with a client and says, we're going to ask for $100,000 in this case, goes over and loses the case, and then tells the client, we thought we were going to get 100,000, so you owe me 30,000 in a contingency fee. And the client, of course, says, well, we were supposed to recover. Well, there was no event here that would have triggered any kind of commission, no sale, nothing that ever would have triggered a conditional commission in this case. So you're stuck with there's either no commission because nothing ever would have triggered it, or else you're looking at a reasonable hourly value of the work, and there's just nothing to support in the evidence, nothing to support the number of hours that were spent or the reasonable compensation per hour. And so there's no basis that you can have any kind of a quantum merit recovery in this case, based on the evidence.
They agreed to pay a commission and there was a triggering event. Is that percentage commission itself evidence of what's reasonable?
Of what they might have agreed to pay? Mm-hmm. Well, of course, it depends on the kind of contract. Attorney fee contract, it's not enforceable.
Of course, in a quantum merit, you wouldn't have a contract.
Yeah.
But they're saying because they're referring to other arrangements where they had an agreement to pay a commission, that agreement and the commission mentioned therein can be evidence of what's reasonable in this situation.
Well, the evidence just isn't that way in this case. And the reason is because Mr. Hart testified that there was no set commission, like it wasn't 0.8% or anything, 8% or anything like that. Mr. Hart, what their arrangement with Mr. Besselman was at the completion of each sale, he would pay an amount in his discretion, which he thought was fair. And Mr. Besselman said he never disagreed with any of those amounts. He always thought they were fair, and he was paid a significant amount of money over a significant period of time.
Let's assume that Mr. Hart its testimony cannot be credited. Okay, so we take out what he said about the commissions. Did Mr. Besselman testify about what the commissions were that he thought he would be receiving? The
No.
amount of commission?
No, the only testimony in that, the only evidence in that regard was a list of the amounts that Mr. Besselman had been paid. And and when you add all those together and the amount of the total sales of those wind turbines, it came out to about that percentage that the trial court ended up using. But no, there was never any discussion. You're going to be paid any set amount on any of either the wind turbines or the USVI project. There was no set standard amount or anything like that.
You're not arguing though that you can't ever look at past commission percentages to calculate a quantum merit damage though, right?
No, I think if I did that, I'd be arguing against the precedent in this court. This court has basically said that you can look at a pattern of
You're talking about Spears Huber?
the Spears case.
Is Spears,
I just think that's distinguishable.
is it distinguishable? Because didn't we say that the parties agreed that there was supposed to be a payment and they agreed to the amount of
Yes.
commission? So for purposes of this appeal, we are assuming that their agreement represents reasonable value. We're not saying that. I don't read Spears is saying that commission, past agreements with regard to commission is evidence of reasonable value. We just assumed they were there.
Yeah, I totally agree. Your Honor. I think Spears is completely distinguishable from any of the facts of this case. So, thank you all very much.
Thank you, Counsel. The case is submitted and you are free to go. And again, we appreciate your cooperation in this setting today. And we will be in recess until further notice.
All rise.